Hey everyone, welcome back for another deep dive. Today we're going to be taking a look at something a little different, We're diving headfirst into the world of Missouri traffic law.
Buckle up.
Yeah, get ready. Because we are talking about driving with a revoked license, specifically Section 302.321. Driving while license or driving privilege is canceled, suspended, or revoked.
This one is a doozy.
It really is. And, at first glance, it might not seem like the most exhilarating legal topic, but trust me on this one. There's a lot more to it than meets the eye.
Absolutely, because this isn't just about forgetting to renew your license.
Right. We're not talking about a little, oops, I forgot to pay my renewal fee.
Right.
This gets serious. Like, what is this criminal negligence thing?
Yeah, so criminal negligence, it's a crucial phrase here. What it boils down to is this. Missouri law wants to make it crystal clear that there's a big difference between just, spacing on your license renewal and knowingly breaking the law.
Okay, so help us understand that distinction. What does criminal negligence actually mean in practice?
So, in a nutshell, it means that the state, they can't just show that you were driving with a revoked license. To get a conviction under this section, they've got to prove, beyond a reasonable doubt, that you knew your license was revoked and you still chose to drive. They have to prove intent.
Okay, so it's like that whole knowingly and willfully thing you hear in legal dramas.
Exactly. That's exactly it. It's about proving a deliberate disregard for the rules of the road, not just a simple mistake or oversight.
So it's less, oh, shoot, I totally forgot about that suspension, and more like, I know I shouldn't be driving, but I'm going to risk it anyway.
You got it. And that's a critical distinction because that's what elevates it from a simple administrative blunder to a criminal offense.
Interesting. So let's get down to brass tacks here. Can you give us some real-world scenarios where this might come into play? Like, what kind of situations are we talking about?
Sure. Let's say you have someone who has multiple DUI convictions, right? They know their license has been revoked because of their past offenses, but they still get behind the wheel. That's a classic case of criminal negligence. They know they're breaking the law.
Right, they're fully aware. Okay, what else? Give us another example.
Okay, how about this? Someone gets pulled over for driving on a suspended license, right? Instead of addressing the issue, taking care of it, getting things squared away, they just keep on driving until they get caught again. Now, that is a prime example of criminal negligence.
Because they knew better. Right, they were aware of the situation, but they just chose to ignore it.
Precisely. And these types of situations, sadly, they happen way more often than we'd like to think, way more often. And the penalties for driving with a revoked license in Missouri, oh boy, you don't want to mess with these.
Okay, so let's get into it. What kind of consequences are we talking about here? Lay it on us.
Well, for starters, even a first offense can hit you with a Class D misdemeanor.
Class D misdemeanor, huh? For our listeners who aren't fluent in legalese, what does that actually mean?
It translates to a hefty fine. We're talking up to $500. And you get this possible jail time, even for a first offense.
Wow, okay. So, not something to take lightly. No slap on the wrist here, they mean business. But why so harsh? Why do you think Missouri has such strict penalties for this?
I think it sends a clear message about how seriously Missouri takes driving privileges. They want to emphasize that it's not a right, it's a privilege. And when you abuse that privilege, especially in a way that could put others at risk, there are real consequences. It's all about public safety and deterring reckless driving.
It's like they're saying, we're not messing around here.
Right, exactly. And it gets even worse. If you get popped a second or third time for driving while revoked, you're looking at a Class A misdemeanor.
Which means?
Even higher fines, longer potential jail sentences. It escalates quickly.
And if you're really pushing your luck, what happens if you rack up a fourth offense? Or more?
Fourth or subsequent offense, you're entering felony territory. That's a Class C felony, my friend.
A felony. Okay, so now things just got really real. Because a felony on your record, that's life-altering, right?
Absolutely. We're talking potential prison time, massive fines, and a permanent mark on your record that can affect everything. Jobs, housing, loans, even education. A felony conviction casts a long shadow.
And to add insult to injury, Missouri law gets really specific about those penalties. You've got mandatory minimum sentences. So even if a judge wanted to go easy on someone, their hands are tied. Then there are things like community service requirements, limitations on parole or probation. It's a whole ordeal.
It's designed to be that way. They want to make sure those consequences are felt, They want to make people really, really think twice, 3 times even, before even considering driving with a revoked license.
Yeah, no joke. So we've talked a lot about the law itself, but are there ever situations where it gets a little, I don't know, murky? where it's not so clear-cut how this section actually applies.
Oh, absolutely. You would be surprised how often a law that seems straightforward on paper can turn into, like, a real head scratcher when you apply it to a messy, real-life situation.
Because the legal system is never simple, is it?
Never. Take, for instance, this wild case from 1968, State v. Cipolla. This one really highlights how the tiniest details can become huge deals in the courtroom.
Ooh, a 1968 case. Now we're talking. What happened? Give us the lowdown.
So in this case, the information charging the defendant with driving while revoked, it didn't actually use the specific phrase driver's license. And get this, it didn't specify under which statute his license was revoked either.
Wait, hold on. So they were basically like, you were driving while revoked, but didn't bother to say what was revoked or why? Seems like a pretty big oversight.
You'd think so, right? But here's the crazy part. The court still upheld the information.
Seriously, how could they let that slide?
Because they decided to focus on the heart of the matter. They argued that, look, it was clear the defendant understood the gravity of the situation. The information, even without that super specific language, still got the core message across that he was violating a court order by driving. The guy knew he wasn't supposed to be behind the wheel, plain and simple.
So even though the language wasn't perfect, the court was basically like, we get the gist of it.
Pretty much. And you know what's interesting about that? This case really solidified the idea that it all comes down to knowledge and intent. It's not just about knowing your license is revoked. It's about knowingly defying the state's order to stay off the road.
Okay, so lesson learned, always read the fine print, even if the legal system sometimes forgets to.
Yeah.
But speaking of things that aren't always clear-cut, we found another case that really throws a wrench into things.
Yeah.
This one involves a vehicle so unusual, so out there, that it'll make you question everything you thought you knew about cars. We're talking about State v. Gardner, a 1975 case that screams, only in Missouri.
Oh, yeah, this one is wild. Like, picture this.
Picture a mashup. You, a glorious Frankensteinian fusion of a foreign car, a motorcycle, and a whole lot of DIY ingenuity.
Part junkyard masterpiece, part fever dream. This thing was something else.
This guy built his own hybrid vehicle, and the court had to figure out if this contraption even qualified as a motor vehicle under Missouri law. Because if not, then this whole driving with a revoked license thing, it's a moot point.
Yeah. You see, this is why we love diving deep into these cases. The law, it has this way of having to adapt to things like, changing technology, unusual vehicles, and sometimes just plain old human creativity. I mean, where else are we going to see a case that hinges on whether a homemade car-motorcycle hybrid counts as a motor vehicle?
Right. And it's like if it walks like a duck and quacks like a duck,
Yeah.
but it's made out of spare car parts and a lawnmower engine, is it still a duck?
Exactly. And in this case, the court ultimately decided that yes, even though it was one of a kind, that crazy contraption was a motor vehicle. No escaping the law for our creative mechanic.
So no legal loopholes for DIY enthusiasts. Even if you're cruising around in something straight out of a Back to the Future sequel, you got to follow the rules.
You got it. And it reinforces a crucial point here. The law needs to be flexible, to encompass all these new situations, new types of vehicles. We're in a world now with electric scooters, those beefed up golf carts you see, even ATVs, the lines can get blurry. But the heart of the law remains the same. It's about public safety on the road, no matter what you're driving.
It's like that saying, you can't outrun the long arm of the law, even in a homemade motorcycle car thingamagic. But jokes aside, this whole thing about knowing whether or not your license is revoked, it got me thinking, how do you even know if your license is revoked in the first place? Like, what if you just missed the memo?
That is a fantastic question, and it takes us to another case that really zeroes in on this whole idea of knowledge as a key factor in these cases.
Okay, so another case, more insights into this whole knowledge aspect.
Yeah.
Hit me with it. What's the story here?
This one takes us to 1987, State v. Horst. It's a case that really set a precedent for how important it is to prove the driver actually knew their license was revoked.
Okay, so no more assuming everyone's eagerly checking their mail for revocation notices.
Not a chance. This case really drives home the point that you can't just assume someone knows they're breaking the law. You have to prove it. No shortcuts. It's a cornerstone of our justice system. Innocent until proven guilty, right?
Right, of course. But proving they knew. That sounds pretty tricky. How do you even go about doing that?
It definitely takes some work, Hugh. Prosecutors might use certified mail receipts to show the person was officially notified. Or maybe they can point to previous convictions that should have made it obvious the license was revoked. Sometimes they might even bring in testimony from police officers who had previously warned the driver about their license. It's all about building a solid case, piece by piece.
So it's a bit of a legal puzzle, connecting the dots.
You can say that, but the bottom line is, the burden of proof is always on the prosecution. They're the ones who have to convince the court that the driver was in the know, that they were deliberately and intentionally driving while revoked. That's what separates a simple mistake from a criminal act.
Man, this whole deep dive has been eye-opening. I mean, we often think of traffic violations as open and shut cases, but there's so much more to it.
Absolutely. What we see on the surface, it's just the tip of the iceberg. These cases, they reveal a whole other level of complexity. The law itself is just the starting point. It's the interpretation, the application of that law that really shapes how it impacts people's lives.
It's like the legal system is constantly evolving, trying to keep up with all the curveballs life throws at it. New situations, changing technology, and, well, let's be honest, human nature. Because people will always find ways to test the boundaries.
That is a universal truth. And that's why it's so important to understand the law. Even something that seems as simple as a traffic violation. Because as we've seen today, what starts with a simple traffic stop can quickly escalate into something far more serious.
Absolutely. Well said. So as we wrap things up here, any final takeaways you want to leave our listeners with? What's the big picture message about driving with a revoked license in Missouri?
The big takeaway here, is that Missouri is serious about this. Dead serious. We're not talking about a slap on the wrist. These penalties are tough, they escalate quickly, and the consequences can have a ripple effect on your life for years.
It's not just about the legal trouble. It's about the risk you pose to yourself and everyone else on the road. Driving is a privilege, not a right, and it comes with responsibilities.
You hit the nail on the head. When you're behind the wheel, you're agreeing to follow the rules of the road. A revoked license is a sign that somewhere along the way, that trust was broken.
So to everyone listening, do yourselves a favor and stay informed. Know your driving status, understand the restrictions, and if you ever find yourself facing a revoked license, take the right steps to get back on track, legally and responsibly. It's always better to be safe than sorry.
Couldn't agree more. Take it seriously, folks. And on that note, looks like we've reached the end of our deep dive for today.
And as always, we appreciate you joining us as we take these deep dives into the fascinating and sometimes perplexing world of Missouri law. Until next time, drive safe out there.